Welcome everybody in the Substantive Criminal Law panel of this conference. I am very happy and glad to be here and be the moderator and the panel leader of this panel. First of all, I would like to introduce the members of our panel discussion. Dr. Margita Prokeinová, full professor from the Comenius University, Slovakia. Dr. Vera Kalvodová, full professor of the Masaryk University. Dr. Marcin Wielec, full professor from Cardinal Stefan Wyszyński University. Dr. Silvia Vetter from the University of Veterinary Medicine of Hungary. And last, my name is Udvarhelyi, associate professor from the University of Miskolc. I'm sorry if I pronounced your name not correctly, but hopefully it will be okay. So first, thank you very much. Thank you. First of all, I would like to make this short presentation, comparative aspects about the criminal law protection of the environment of the selected countries. It cannot be disputed that the intensive technical and economical development of the 20th, 21st century has not only positive but negative consequences. One of these is the damage to environment. The preservation and the protection of environmental values have a fundamental importance from the point of view of the human health and the quality of life. Environmental criminal offenses cause serious harms to the society and to the future generations, since natural resources are finite. One of the most important characteristics of criminal offenses against environment is that their consequences usually doesn't stop at the state borders, but they affect more states. Environmental crimes are also connected to the organized criminal groups, and these crimes are often committed together with other criminal offenses, for example, fraud, corruption, or money laundering. Along with drug trafficking, human trafficking, and counterfeiting, environmental crimes represent one of the four most prevalent criminal activities in the world. Because of their particular seriousness, a complex and comprehensive toolbox is required in order to fight effectively against environmental criminal offenses, both at national, international, and EU level. At national level, several branches of law, either private or public law, play an important role in this issue. Administrative and civil law could provide for an effective reaction against environmental harms. However, in case of the most serious forms of environmental violations, the application of criminal law as a last resort has also been taken into consideration. While administrative sanctions mainly serve as a preventive and corrective function, criminal law provides the possibility of imposing more severe forms of sanctions on the perpetrators, which corresponds to the seriousness of the act. However, environmental criminal law should focus only on the most serious forms of environmental violation, which is in line with one of the most important criminal law principles, the principle of ultima ratio. In the next part of the presentation, I would like to shortly present the categories of environmental criminal offenses in the four countries, and after that I would like to draw your attention about some common regulatory features in the countries. First, the Hungarian environmental criminal law system. The Hungarian criminal code regulates the environmental crimes in a separate chapter. The criminal offenses which can be found in this chapter can be distinguished or classified into three categories: the pollution-related criminal offenses, including the damaging the environment and the violation of waste management regulations. The second is the crimes related to animal and wildlife protection, damaging natural environment, cruelty to animals, abuses related to the trade of companion animals, poaching game, poaching fish, and organization of illegal animal fights. The third category is the criminal offenses in connection with the misappropriation of different hazardous activities or substances. In Hungarian criminal code, we can see that the law doesn't punish any hazardous activities or the use of any hazardous substances in general, but only their most serious forms, namely the ozone depleting and the nuclear radioactive substances. If we briefly analyze the criminal offenses in the other third countries, similar provisions and the similar categorization could be observed. If I am mistaken, my distinguished colleague could, of course, correct me. The Slovakian criminal law also regulates pollution-related offenses, including the damaging the environment and the illegal waste management. And it also punishes as a separate offense the unauthorized discharge of pollutants. The wildlife and biodiversity crimes are similar that in Hungarian criminal law, but the Slovakian regulation contains some criminal offenses which are not regulated in Hungary. For example, the spread of contagious animal or plant diseases or the release of organisms. The forestry and land use crimes encompasses the violating of protection of trees and shrubs by the unauthorized construction, while the so-called industrial and corporate crimes cover the illegal production and possession of nuclear materials, radioactive substances, and other hazardous substances. The 17 criminal offenses which the Czech criminal code regulates can be divided into several groups. The general criminal offenses affecting damage to or endangering the environment, the provisions protecting certain components of the environment, the provisions penalizing certain specific acts against the environment, and the provisions protecting animals against mistreatment and punishing poaching. In the Slovakian and the Czech criminal law system, we can observe a bit more detailed regulation compared to the Hungarian system, but most of the criminal offenses are similar. From the four examined countries, the Polish criminal system follows a more abstract approach. It contains fewer criminal offenses, the criminal code, among which, however, we could find the classical pollution-related offenses, illegal waste management, or misappropriation with radioactive materials. If we want to draw up some common features in the regulation of the four countries, we can observe first of all that the scope of criminal offenses are very similar. Some countries follow a more detailed, while other a more abstract approach, but the punishable conducts are almost the same. Secondly, the countries try to respect the criminal law principles, namely the principle of ultima ratio and subsidiarity, when regulating and criminalizing the environmental crimes. There are several qualitative and quantitative thresholds which aim to secure that only the most serious environmental violation shall constitute a criminal offense. Further common feature is that several regulated criminal offenses are so-called blanket dispositions, which means that their content is highly influenced by the administrative law. For example, the determination of the basic definitions or the condition of lawfulness, unlawfulness can be found in administrative regulation. It means that the administrative and the criminal law have a great interconnection. Administrative norms play an important role in the establishment of criminal liability. In the four countries, the principle of guilt prevails. As a general rule, intentional conducts are punishable, while in case of lot of criminal offenses, negligent or gross negligent conducts also punishable, but the strict liability is excluded in the countries. The countries also provides from the possibility of the sanctioning of both natural and legal persons with different sanctions. Because of the seriousness of the environmental offenses, the countries try to prescribe effective and deterrent criminal sanctions for these criminal offenses. The most important criminal penalty is imprisonment, but national legislations also define other possible sanctions, for example, financial sanctions, community services, or prohibition of carrying out certain activities. In this context, it has to be mentioned that there are some examples of specific sanctions in the national legal systems which expressly related to environmental criminal offenses. And finally, it also worth mentioning that in some countries, the legislation provides the possibility for restorative measures based on the recognition that it is more important to restore the damaged environment than to punish the perpetrator. For example, in Hungary, if the perpetrator voluntarily terminates or cleans up the environmental damage, he or she cannot be punished for damaging the environment, or in some cases, he or she can be punished, but the punishment can be reduced without limitation. Similar provisions can also be found in the Polish criminal law system. Last but not least, I would like to draw your attention about some future challenges in the environmental criminal law. Environmental protection by the means of criminal law can be considered to be quite successful in the countries, providing sufficient protection for the environment and its components, and also respecting the principles of subsidiarity and ultima ratio. The level of sanctions and the categories of sanctions are also meet the requirements of effectiveness and seriousness. However, a big problem in connection with these offenses is that the high level of latency prevails, and the number of the actually committed crimes which are reported to the authorities are not equivalent to the crimes which do not reach the attention of the authorities. One of the main reasons of this high level of latency is the fact that the proof of these criminal offenses could be quite difficult in the practice. In case of causing environmental damage, it is often difficult to determine to certainty what was actually damaged and what was the extent of the damage. It is difficult to find the monetary equivalent to express environmental damage because the quantification of environmental damage can only be approximate in a lot of cases. Activities endangering or damaging the environment often remains hidden for years or decades. Their negative effects could be demonstrated in the second or third generations. In case of pollution-related offenses, it is also quite often in practice that the damage to the environment is the result of cumulative factors, not only the pollution, which makes the proof of causality and the proof of guilt, so the proof of the subjective mens rea elements, extremely difficult. The causal connection between the offender's conduct and the environmental effect, the negative environmental effect, can also be a key point in this context. In a complex ecosystem, it is often very difficult to clearly determine what was the act of the accused that caused the given adverse effect and not other factors that could have influenced this effect. Due to these difficulties relating to evidence, the assignation of forensic experts is often required in these cases, which could, however, result in an excessive duration of criminal cases and the increase of the procedural costs. The second important challenge which I would like to mention is the implementation of the new EU directive on environmental criminal law in 2024. The aim of this new legal act is to establish minimum rules with regards to the definition of criminal offenses and penalties in order to protect the environment more effectively. The new directive significantly expanded the scope of environmental criminal offenses. While the previous EU legal act contained 9 criminal offenses, the new EU directive regulates a total of 20 different punishable offenses, which means that there are 11 new criminal offenses, for example, illegal manufacture of mercury products, illicit ship recycling, illegal timber trade, or the importation of invasive species into the territory of the European Union. This, of course, faced challenges to the national legislators, since not all of these criminal offenses are expressis verbis covered by the national criminal law systems. In connection with the sanctions, the directive not only strengthened the or expanded the scope of criminal offences, but also created a more severe system of penalties compared with the previous EU legal act. The new directive prescribes the minimum amount of imprisonment in a progressive scale from 3 to 5 years in the basic cases and from 8 to 10 years in case of the aggravating circumstances. Besides the imprisonment, other additional sanctions are also listed in the directive, for example, the obligation to restore the environment or to pay compensation for the damage to the environment. In order to provide compliance with the provisions to the directive, the penalty level of these criminal offences also has to be increased in some cases. In Hungary, it is sure because some of our criminal offences have lower criminal penalties than it is determined in the EU requirement. And also the introduction of new sanctions which are listed in the EU directive can also be fined considerable in this case. The member states are required to implement the directive by the 21st of May 2026. So we have more than half year now until the deadline of the implementation. In this point, amendments from the legislation is required in order to provide the full consistency between the new EU requirement. Thank you very much for the kind attention.
So thank you for the floor. Dear colleagues, ladies and gentlemen, first of all, I would like to thank for invitation to this excellent event. I'm very pleased and honored to be here. I would like also ask for this interesting question, so I'm going to answer it. The punishment of prohibition of breeding and possession of animals was introduced into the Czech criminal law in 2020. It was a part of so-called Animals Amendment, which provides high level protection to animals. Besides this new penalty, also the new criminal offense of keeping animals in unsuitable conditions was introduced. And also this amendment increased the maximum term of sentence for animal cruelty. What was the reason for introduction of this new punishment? To quote explanatory memorandum, this penalty is intended to compensate for shortcomings in the imposition of penalties prohibiting activities and forfeiture of things, in this case animal, on persons who have committed criminal offences in connection with the keeping, breeding or care of animals. Prohibition of activity is one of the penalties which can be imposed on offenders, but it can be imposed only if the activity has a character of employment or function or is regulated by the law or requires some permission. So this is why that in cases connected with domestic hobby breeding and mistreating or abusing animals, this penalty cannot be imposed. This is why the legislature decided to introduce the new type of punishment. The court may impose this penalty if the offender has committed a criminal offense in connection with the keeping, breeding or care of an animal. This penalty may be imposed separately, but is more likely to be imposed alongside a form of imprisonment or another type of penalty, such as a pecuniary penalty. The essence of this penalty is that the convicted person is prohibited from keeping, breeding, and caring for the animal for the duration of the sentence. This punishment can be imposed both physical or natural and also legal persons. The differentiation is in the length. For adults, maximum term of this penalty is 10 years, for juvenile 5 years, and for legal entities up 20 years. A little bit problematic aspect of this punishment is the control. This task is entrusted to the veterinary administration. This is an entity that is in no way connected with criminal proceedings, yet the Criminal Procedure Code grants it significant powers in the form of entry into dwellings, other premises or land. And the question is whether the control should be carried out by the police in cooperation with the veterinary administration. One of the questions is also how should the content of this punishment be defined in the judgment? Is a general ban on owning, breeding, and caring for animals sufficient, or should the animal or group of animals be specified in some way? For example, if the perpetrator kept certain animals in unsuitable conditions and at the same time kept another animal that he cared for properly, for example, a dog or cat, there wouldn't probably be no reason to impose a general ban on keeping, breeding, and caring all animals. The question was if I found this punishment effective. I'm not sure. I'm not sure because on the other hand, it provides protection for cases for which is not possible use the prohibition of activity. That's right. I think it's a good idea. On the other hand, we can imagine the case when one member of the family committed a crime of animal cruelty. The punishment is imposed on one member of the family, so the provision should be only applied to this perpetrator, not the rest of the family. It's not possible to prohibit keeping animals for children, for wife or husband, so it can be a problematic aspect. So time is out, so thank you for attention.
Thank you very much, ladies and gentlemen. In Slovak Republic we have many alternative punishment, but this type of sanction we don't have in criminal law, but it's possible to impose financial punishment or obligatory work in case obligatory work minimum limit is 40 hours and maximum limit is 300 limit. In case in financial punishment is minimum limit 160 euro and maximum limit is 3 million euro. And it's all for my first answer.
Bence, thank you very much for this question. Yes, it's true that in Polish criminal law system, extra code law plays an very important role also when it comes to environmental crime. And to understand how it works, we need to look at the structure in general of our criminal law system. It has four parts basically, and part one, it is very shortly, it is the substantive criminal law. It is mainly the code, criminal code, which says what crimes are, what the punishment are. Part two, very shortly, criminal procedural law. It's my area of interest, scientist interest, and this is the code of criminal procedure, which says how criminals are caught and judged in the court, and the methods of collect evidence, evaluate this evidence, adjudicate, and so on. Part three is executive criminal law. This regulate how punishment are carried out, and part four is this extra code criminal law. These are criminal rules that are in special laws, not in the criminal code. And this fourth part is totally key to your question. That extra code law for environmental crimes includes many areas of laws that regulate different parts of environmental protection. I distinguish two groups of this relation. This, in my opinion, this character of this is totally complementary. And for example, the group one is provision outside of criminal code that covers criminal area. This rather administrative law and, for example, the environmental protection law. On the first glance, this is a law act completely unrelated with area of criminal law. It says what the standards are, what good quality environment, how to use nature, and who is responsible for environmental damage. Waste law, it regulates what to do with waste, like collecting, like transporting, like processing, and getting rid of it. Nature protection law, very shortly, it protects important nature area, plants, animals, and beautiful landscapes, of course. And even atomic law in Poland, it says what materials and radiation sources are and what the safety rules are. Group 2, very shortly, is most important thing here. It is because it is, for example, the issue of combining criminal liability with responsibility for misdemeanors, petty offenses. In example, let's say very simply, for minor acts of a criminal and administrative nature, but more on that in a moment. And therefore, the question arises, how does all this connect to criminal responsibility for environmental crimes? Well, the extra code laws often have rules that say what you must do and what you can do to protect the environment. And if you break these rules, you can be held criminal responsibility under the criminal code. To show this better, let me give some real examples, real life examples directly from my advocate's practice. And for example, illegal storage of dangerous waste. Imagine a company, I don't know, X, Y, Z, I don't know what makes things, but and has dangerous waste, of course. And instead of giving it to a company that can get rid of it softly, they store it illegally on their own land, breaking in this way the waste law. Because of this, there is a criminal case, and the owner of this company is responsible under Article 183 of the Polish Criminal Code for illegally managing waste. Illegal cutting down of trees, for example, in a protected area. Person, I don't know, X, illegally cuts down trees in Natura 2000 area. Breaking the nature protection law, this cutting down destroy the homes of protected plants, protected animals, and there is a criminal case. The extra code law, if you want to see, says what area are protected and what can do here. And without these rules, it wouldn't be possible to say if a crime happened. And let me return to the responsibility for misdemeanor for a moment, because in Polish we use the term split offenses. Split offenses to describe acts that can be treated in two different ways, either as a petty offenses, misdemeanor, or as a crime, depending on how serious the situation is. We are talking here about the criminal law outside of the penal code, because this is about petty offenses law, and here we find, as I mentioned, special construction called in split offenses in Polish, czyny przepołowione. The same behavior, like illegal waste storage or pollution, can belong to either category. The differences depends on clear criteria that the law and courts, for example, use. In my opinion, is the four. The first, the scale of damage. If the harm to the environment is small or local, it is a petty offense. If it is large or widespread, it becomes a crime. Second, the level of danger. If there is no real threat to people or nature, it is treated a minor case. But if there is a real risk to health or serious pollution, it is a crime. The third, the intention and behavior of the offender. If the person acts carelessly, it may stay in the petty offenses category. If the act is intentional, for example, repeated, it usually becomes a crime. And four, the violation of legal permits or obligation. When someone only slightly breaks administrative rules, it is usually a petty offense. But when they ignore or seriously breach environmental permits or some kind of bans, it becomes a criminal matter. And for example, if a person burns a small amount of household waste in their backyard, for example, it is a petty offense. But if the company burns large amounts of industrial waste causing toxic smoke and pollution, for example, it becomes a crime under Article 182 in Polish criminal penal code. So, to put it simply, petty offenses cover minor or local harm, while crimes deal with serious large-scale or dangerous harm. This distinction helps to keep the system proportionate and fair. Criminal law is used only as a, you mentioned about it, only as a last resort, ultima ratio, when environmental damage is really, really serious. Thank you very much.
How many time do we have? 2 minutes. Oh, it's so unfortunate. Okay. It's so unfortunate to be the last presenter before lunchtime, so I try to be colorful a bit, if you don't mind. I could speak about the law, for example, cruelty to animals in Hungary, or organizing illegal animal fights or nature damage, but maybe it's more important, because of the short time, to emphasize why is it relevant, why is it actual. I think if we are talking about anything in the world, we should ask these two things. Is it relevant? Is it actual? And my answers are absolutely clear. Is animal protection relevant? I think yes. Imagine this. This is an absolutely fast developing field of research. Animal protection is a new field of research, like a little brother of the environmental protection. But it's not so easy to define what is animal protection, because it's not clearly part of nature protection. One part of animal protection is part of nature protection when we are talking about, maintaining biodiversity or protecting the different species of animals. But what about the protection of the individuals of animals? Individuals of different species which are absolutely not endangered, which are absolutely not rare. What about the protection of the individuals of dogs and cats, for example? It's not part of the nature protection. It's something different. But is it relevant? Yes. Why? Because of religious reasons. For example, if you are reading the holy books of the big religions worldwide, you will find that we have to be responsible owners and keepers of the other creatures. Or from the ethical side, every person who has got mental health for them, it's clear that we should minimize the suffering around us. Suffering of people, and suffering of other creatures, such as animals. Or, for example, economic reasons, productivity. If, the animal stock is healthy, then the morbidity will be lower, the costs of the veterinarian care will be lower, and so on. Or zoonotic diseases, for example, such as COVID-19. I think you can all well remember this period of time. So diseases which can spread from people to animals and reversed from animals to people. Or the positive psychological effects which animals do have on people, like animal-assisted therapies and interventions. You can measure it, the good health effects which animals have on people. Or, which is one of my fields of research, is the deadly link, the so-called deadly link, and it has got a strong connection with criminal law. When we are talking about animal cruelty, researchers have found in the last decades that yes, we have a strong connection, a close connection between animal cruelty and violence against people. So, when we are talking about the escalation of violence, which is starting with bullying and some kind of antisocial behavior. These are the beginning states, the beginning levels. Later on, at the middle of the letter, we can find animal cruelty then. And after that, the very violent behaviors like a murder or serial murder or rape or sexual assault and things like that. So if you could stop violence in the middle of the letter, so at the stage of animal cruelty, you can avoid violent behavior towards people. So is it relevant? Absolutely yes. Is it actual? Absolutely yes. Why? And this is a very, very new story in Hungary. Last night we had an absolute scandalous news story in Hungary. It spread all of the press in Hungary, social media and media as well. Civil organizations, members of civil organizations, together with the police, went to a dog pound, an animal pound, an animal control place, and there they have found dead bodies of animals, dead bodies of dogs, like garbage, and other signs of animal cruelty. So there was an accusation made today. This year, the parliament made the criminal code stricter regarding animal cruelty. We have a new form of aggravation case, which is about animal cruelty in an animal shelter or in dog pounds. That you have to take those cases more serious because they should be, the protector of the animals, not the abuser of the animals. And in this case, people can have 3 or, in aggravated form, 5 years of imprisonment regarding the new law made this year. So this case, which happened last night, will be the first one based on this new aggravated case made this year. So the Hungarian law, and I'm absolutely sure that the situation is quite the same in the region, is regarding animal protection is stricter and stricter each year. It's different, more and more differentiated. There are more and more offending behaviors, or we have an absolutely new crime which is about the trade of companion animals, about puppy milk problems. I could talk about that for an hour, but I don't do that now. Thank you very much for your attention and have a great break.